think my mother every year got a report that I was really hyper in class, so me standing behind this is not going to work, so move that out of the way. And most of you probably already know that about me. So my background, I've been in the industry for, if you don't know this, I won't bore you too much, but since 1999. So it's getting less cool every year to say how long I've been in the industry. It's been now 24 years. Maybe I'll just switch to 20 plus years. But I've always worked in healthcare. I started at a lab, then went to a startup, and then went to EV3 Covidian, where I met Dawn here and a bunch of other people I stay in touch with still today. I then started practicing law. That was 14 years ago. I worked at a boutique firm for 7 years and then started Gardner Law 7 years ago. And as you probably know, I think I mentioned earlier, we focus on regulatory compliance and privacy, and that's it. I also teach at Mitchell Hamlin, start teaching at the University of Minnesota Law School and Carlson now. So the last thing I'd say is for the attorneys here, and actually our section for the MSBA, Food, Drug, and Device Law section, we also, it's not just attorneys, we have regulatory quality professionals. Just a quick plug for them. It's a great local group that talks about a lot of the things we're talking about here today. So I'd encourage you to sign up if you're not already a member. So I'm going to cover this Goldilocks zone concept. And I'll talk about top due diligence questions. We'll talk about where folks are likely to focus if you are the target of an acquisition, if your company's being bought, or if you're buying a company. I'll give you some tips on what I think you should focus on. And also talk about the fun data room. Everybody is familiar with the data room. Some case studies and how to prepare. And I have some time for Q&A as well. I think we're actually ahead of schedule for the first time in the history of our programs. So I won't use up all that time because I'm sure we'll spend it elsewhere, but we will have time for some questions. So, audience question, are you or have you been involved in acquisitions? Raise your hand if you've never been involved in one. Okay, got a couple folks. And everyone else, yes, has been involved. Okay, how many were the buyer? Seller? Both? Okay, I probably should have put both on there as well. Yeah, it's pretty common in our industry, right? In medtech, pharma, it's seems to be a pretty popular model. We've got our big strategic companies out there and we have a really robust entrepreneurial group in this country that's constantly developing new drugs and medical devices. So the big fish eat the little fish, right? And that seems to help humanity because the big fish are particularly good, one would think, at getting those innovations out to the physicians. Not always. Rebecca, question. Oh, thank you. Online results. Thank you very much.
Yeah, so 29% said no, 38% said yes as a buyer, and 33% said yes as a seller.
Okay, great. So more folks that haven't been involved in a transaction that are online. So good. Well, we can give them pull back the curtain here and give them some tips because I'm sure they probably will eventually be part of one. Okay, so the Goldilocks zone. Did anyone know what that was before today? All right. Okay, one. Yeah, I had initially called this, or I was thinking it was going to be like the good, bad, and the ugly, M&A due diligence. And then for whatever reason, because I'm a nerd, we were in Mexico and I went online. I was working on this there. And I discovered that like 4 or 5 other law firms had that same title for this activity, and so I had to come up with something new. So I meditated a bit, took a nap, and then this is what I came up with. So the Goldilocks zone, I'm just going to read this. This is from NASA. It's a habitable zone around a star where liquid water can exist on the surface of surrounding planets. Like the third of the 3 bowls of porridge in the tale of Goldilocks and the 3 bears, this is the sweet spot where it is neither too hot nor too cold, but just right for life to exist, right? So if you're going to buy a company, you want to be in the Goldilocks zone. You want that target to be in the Goldilocks zone. I suppose if you are being bought, you want your strategic to be in this zone as well, unless you're going to leave the company shortly thereafter. So applying that, that concept to buyers, and again, Amanda's going to expand on this after me, but we kind of thought about this. I think I actually called Amanda from Mexico, so she's also a nerd with me. But we said, a company that's too cold. So if you're a strategic looking at a startup, if they lack necessary regulatory compliance and privacy controls. So again, this would be like if the QMS is a mess. No, not trying to make a joke there, but their compliance program is just off or non-existent. If the privacy controls, they're like GDPR, what's that? And they're heavily involved with Europe. This company is too cold. They're not really sophisticated, or perhaps they're naive when it comes to their approach. Because these things are so important today now that companies will say, hey, I'm not buying this company because their entire setup is they're bribing doctors, right? Like if you think, hey, there's this great business and you peel back some layers and you find out that half of the customers of the company are consultants, that's a huge red flag, and you should walk away from that deal. I'm not sure about privacy necessarily. That maybe is remediable, which Paul will hit on. Paul will probably disagree with me and say, no, that could also be really bad because there's companies in Europe getting fined hundreds of millions of dollars, right, Paul? So these are things you got to consider before you make the buy. Same with regulatory, if the QMS is just, it's a problematic situation. Let's say if there's tens of thousands of complaints coming in and there's no MDRs as a result, there's, what's happening there, or that those complaints aren't being used to improve the product, for example. So that would be too cold. Too hot would be, they have a great compliance program and other programs, but they just don't comply with them. So the person that's leading compliance is just people aren't following that person's rules and direction. And maybe it's even a top-down approach. Hey, we're compliance, yeah, we got that, but we're just not going to worry about that because they get in the way of sales. That would be one that would be too hot, in my opinion. Or you uncover that conduct that's just clearly illegal. Again, most of the customers say they're consultants. The AVAMed and Pharma Code are just not adopted. Hey, I remember that gift band thing that came out in 2009 or whatever. We're not doing that. Or we're not following that. We're continuing to provide gifts. You start to see some of those red flags that should make you pause and say, gee, this company's too hot. Or they're just not meeting safe harbors. Like the AKS, anti-kickback statute, has safe harbors for things like hiring doctors, for providing rebates and discounts, for warranting product, for having physician investment in your company. So that's my play on that Goldilocks concept. This is really, again, where we're going to focus. We already talked about that. These are all the enforcement branches over here on the right, which you're all familiar with. And this is really the meat of my presentation here now. So if you are in charge of compliance or regulatory or privacy at your company, or all of the above, let's say, I know we have a couple CEOs sign up as well, you should be expected to get all of these questions and all of these. And I could probably, if you talk to me, I could get you, 4 times as many of the questions as this, where I've had clients get just, maybe 80 questions, right? But these 20 are really going to be what I pulled from being involved in M&A transactions for, the last, for my entire career. Really focusing, though, in the last 14 years on this subject. These are the top questions that I see in each deal. So you could use these if you were approaching a strategic. You should also be prepared to answer all of these if you're the target of a transaction. So a lot of these questions are open-ended. I will say this before getting into this. I've been involved in diligence where it's, believe it or not, it might be like a 30-minute conference call with an underwriter or a strategic or whomever. Maybe they went through the data room and were really happy, but that to me is really light diligence. I've been involved in transactions where the quality function alone is audited and reviewed and analyzed and picked apart for a month. So it really depends on the strategic. And I don't have an answer for how many hours you should spend on each subject topic, but I'd say at least a couple days of diligence is necessary. So questions you're likely to get: describe your compliance program. So, what are the policies and procedures that you have? I'll just keep kind of rolling through here. Have there been violations of your compliance policies? There probably should be in most situations. I know Amanda was the compliance officer at Coloplast. There's 1,200 people in the field in North America. You're going to have compliance violations. People are going to go over their meal limits. Maybe a safe harbor isn't going to be followed. You're going to have potential contracts that are out of, maybe they've expired. There's going to be situations where people are going to make mistakes. So if I get a response, because we do these audits for our clients a lot of times they're like, hey, we're looking to have an exit in a year. We want you to come in now and look at us. I'll ask if there have been any violations. And if the compliance officer says no, I'm kind of like, how is that? There should be some violations, arguably. And then it's about how those were remediated, which is what I want to see. How do you vet consultants and employees for exclusion, debarment? So there's free resources online. Every time a consultant is hired, they should be checked against the OIG exclusion list. There should be a SAM check on them. The FDA debarment list should be reviewed. There's also a list for the international, which has a great name. And did you remember the international? It'll come back to us. Sorry to put you on the spot. But there's an international one where, if you're on the international bad guy list as well, you want to look at that. So the people should be, you should be checking them. So if folks are not doing any sort of checks, that's a red flag. Do you perform auditing and monitoring? And if you say yes, I would immediately ask, can I see the reports? And you want to be careful producing those reports. Hopefully they're under attorney-client privilege, ACP. So you're going to not want to share those. Do you have a compliance hotline? These are that. A lot of companies don't have compliance hotlines, which kind of surprises me. This is something the OIG would ask you as well if you're the target of an investigation. It costs for less than $100 a month easily, and it's more like probably $25, $35. You can have a compliance hotline, where there's somebody, a third party, that will just accept complaints on your behalf and then tell you. Do you have a compliance officer? I get that. So when we do these audits, a lot of times it's yeah, we don't have a compliance officer yet. And a lot of times they're commercial companies outselling with 30 reps in the field. You got to have a compliance officer. That's a red flag if you don't. You need to have a compliance committee that meets regularly. And for a startup, that might mean periodic. That might be, once a quarter. It doesn't need to be every week. What's the ratio of HCPs to consultants to customers? So there was the Lifespine case. Sorry to pick on Lifespine. But they had, I want to say the number was half of their customers were consultants, right? And we don't know all the facts around that. Maybe they had a lot of contracts that were open that were just not being utilized. But obviously, if you're the target of a government investigation, they're not going to do you any favors. They're going to say, well, looks like this contract's still open. Even though the physician didn't consult for the last 5 years, it's still an open contract. So I don't know how they did the math on that, but you can read the DOJ website if you want more information or the complaints. But we did work with some clients on that where they wanted us to audit their HCP engagement. And we did find a lot of consultants that were maybe used one time for something. And we said, term those agreements. We want to get this down to a single digit number, and it shouldn't be a high single digit number of, and ultimately the safe harbor, you want bona fide services. That's really one fundamental reason you should hire a doctor. It should never be to curry favor with them. But you certainly do not want to have this ratio be high where you have a lot of consultants. Have you had any recalls, warning letters, MDRs, or other issues? That's becoming a very interesting subject for prosecutors. If you have a faulty medical device or pharmaceutical, and you know that, and then you're shipping it out and selling it to people, the government's going to say you are defrauding us every time you sell one of these products and we pay for it. So under the implied certification theory to the False Claims Act, when the healthcare provider is asking the government to pay for something, they sign off and say everything's on the up and up. If a manufacturer induces that purchase by lying or providing a product that is broken or mislabeled or whatever it may be, or manufactured improperly, that they've induced this purchase, which the government then paid for, or they just made the device wrong, for example. Maybe they didn't tell the purchaser that it was made wrong, but that failure to do something is also, it causes them to be liable, right? So that's a very popular theory right now, is adulterated products and the government saying you're defrauding us. And like the wins, the prosecutorial decisions change. So years ago it was off-label. That was the big topic, right? And it's not anymore because there's so many cases that the government lost. So that's not as an attractive theory to go after, but products made wrong, that's very exciting right now. And then inducement, bribery. Those are the two dominating prosecutorial trends right now. So, and by the way, we all know what whistleblowers are. So you've got potentially the enemy within, right? I'm not trying to color all whistleblowers because they ultimately, if they're being forced to do something they don't believe is right, we want them to raise their hand, right? That's very important. But there's also a financial incentive for a whistleblower that can get up to 15% of a recovery, which if the recovery is $1 billion, that's a big paycheck. So, you got to think like people's decisions may be impacted by that. Yeah, go ahead. Why don't you repeat that?
Sure.
And I'm going to ask my team to listen to this because I do not know.
Sure. In the last 24 to 48 hours, there was a settlement related to a physician inducement for a local company, name I've forgotten, but it was a physician inducement for implantation or diagnosis. So I was just curious if you had a take on that particular storyline.
Yeah, I don't know if anyone else does in the room for our team or not. That has.
I could Google it. Yeah, it was Bloomington, I'm pretty sure.
No. No, I haven't looked at it a lot in the past, but I looked at it briefly, and it was pretty egregious, right? The amount and the physicians and the kind of the scheme of referrals back and forth. So, sometimes you'll see something like that, and I don't expect most clients to have that kind of program in place. But, I think a takeaway from that is, right, when you see something, say something at the outset, because things balloon and grow. And when you're going to get those huge judgments is when it's ballooned to that point where those facts look like that in a fact pattern, right? And that's pretty hard to walk back from in front of the government and say, oh, sorry, this was just a breakdown of compliance, we'll fix it, right? That's a snowballing effect. So like I said, I haven't read every part of it, but I read enough to know that, those facts are what you'd see typically, but that's why it led to such a big judgment. So.
Thank you, Nate. Glad you're paying attention. So I'll just come back to this. We're talking about whistleblowers. I serve as compliance officer under secondment for clients. So does Amanda. And we want whistleblowers we want people that see things wrong to tell us. Let's make that all clear. Point being that any one of your employees in any one of your organizations can become a whistleblower. So if they see something wrong in one of these areas, they may become a plaintiff against your company, right? So that's driving a lot of interest in what we do for a living, obviously, because the stakes are very high for the manufacturers and the officers that run those companies. And I should say that responsible corporate officer doctrine, we've seen it go down to director levels within companies. So it's not, you don't have to meet the officer definition under the law. You might be a director, for example, of reg and still be held accountable under that park doctrine. Or a CFO, sorry, John. You're going to be asked to describe your privacy program policies and procedures. That's a really up and coming, has been for years. Eventually we'll have a federal privacy law because otherwise we're going to have 50 state plus DC privacy laws. So hopefully that will be coming. And maybe Paul can give us more direction on that. But you should be prepared to talk about what you're doing, your privacy policy, your terms of use on your website. Those seem like things like we're like, yeah, whatever. It doesn't matter what it says. We just copied some other companies. You need to know actually what those say because you're going to be asked about them in diligence, and you should ask the target about them and ultimately make sure that they're appropriate. With GDPR, for example, there's real penalties. Here in the U.S., I'll defer to Paul on that, but I think a lot of the heat is on the GDPR. So it's people information coming from Europe to the U.S. especially. That's a big risk area that I think companies are paying attention to. Okay, so we're halfway through these top 20 questions. What's your process for meeting the sunshine requirements? And now we're not just talking about Massachusetts. We've got a multitude of states, depending on whether you're a drug or device maker. If you're a drug, you have more states to worry about. But we have it even down to the city or county level now. So you want to make sure you're paying attention to those rules. I guess from my perspective, if I'm involved and my client says, I haven't filled out any of these things, I just learned about them today, and we've been operating in Massachusetts for the past 8 years, what should I do? My answer is write a big check. So it's going to be $2,000 a year times 8. Send it to Massachusetts, and that's probably going to be the last you're going to hear about it. But you do need to be in compliance with these rules. At any moment, a state AG could change their mind and come after a company. Vermont was active for a bit with their rules. If anybody's dealt with Nevada, we know Leo at Nevada quite well now because he's very active with making sure companies are licensed and registered appropriately. And so I think that's my next one on here. Believe it or not, if you're a medical device or drug company, you need to have a license to distribute your product in most states. A lot of companies don't know about that. We've been really busy with those requirements lately. And there's been some action on the state level with those. How do you handle complaints? That used to be not so much an interesting area for strategics. It's much more interesting now. They're going to ask you about that. And if you have a huge numerator and a small denominator from complaints to MDRs, be prepared to defend that. Like why you took in 10,000, 20,000 complaints and you have one MDR. Is that right? Have you been subjected to government investigation, warning letters, entitled letters, civil investigative demands, other inquiries? I left this question off here, but on one of the lists I was reviewing, because we have a lot of these at our firm, it was, what about your customers? Do they, if they've been, to me, it's sort of like, well, that's the customer, it's not us, but you might be asked that. These all apply to OUS. Generally speaking, philosophically, you're going to be asked about these things with your international transactions. I have with some of our larger clients, they will also they'll do like a distributor audit, for example, because that's usually where all the action is the distributors that are OUS. And I've had questions like, well, how can we audit them ahead of time? And you can, and you should, if you have the resources and time. But my general response or thought is, make sure you're hiring a reputable distributor that's well known. They're probably going to be more expensive, but hopefully they'll be more sophisticated, but not always, right? Like, just because a company is big doesn't mean it's going to be always doing the right thing. Do you perform an annual needs assessment for your consultants? That's an important one, because if you are in a commercial role, sales are down, and you're thinking, well, I'm just going to go and engage a bunch of KOLs so that they start using more of my products. you're not going to be able to do that if you, on January 1st, you agreed to what you already needed. Of course, there's exceptions to this rule where maybe some new need comes up and you go through that, but you should have a robust process for identifying the consultants you need ahead of time. So again, what does that accomplish? It's curbing your commercial team from trying to prime the pump with consulting arrangements or grants or whatever it may be. What are the company's sales and marketing practices as they relate to discounts and rebates? There's very specific safe harbors on point from the OIG. What sort of reimbursement support do you provide? That's becoming a more interesting topic that's looked at a lot more, especially in the pharma side. So it's coming to device. A lot of times OIG starts with pharma and comes to device later. So quick plug for, I'm co-chairing a conference in DC, the FDLI Ad Promo Conference in October, and Mary Reardon comes pretty much every year to that conference. And she's the OIG official that's very influential on policy making when it comes to where they're going to focus their invest their resources. So that's a great conference to go to where you can literally go up to Mary and talk to her. And I've asked her that question. Do you predict any special, any changes to the OIG's take on reimbursement support? And her response is back a couple of years. Now that we're back in person with all this stuff, I'm looking forward to asking this question again this year. But, she's essentially said as long as it's not tantamount to an inducement, you're going to be okay. So your reimbursement support programs should really be focused on supporting the patient, helping them get access to therapy. And it's much more complex than that, but be prepared to defend your support practices from a compliance, regulatory, and privacy perspective. Don't sign BAAs unless you're a BA. If you don't know what those words mean, see me on break. And then describe the company training practices for employees and consultants. And I thought what Jesse said about training is particularly important because a lot of times in audits we'll ask, and you should expect to even be asked for those in diligence, your training materials. And for some reason, there's this misconception that the government won't look at training materials or they don't need to go through our copy review process. They absolutely do. They're arguably more important than any other piece. It's how you're training your salespeople and what you're telling them to do. So the government's immediately going to go to those. So those need to be reviewed and approved. Where will the focus be? I won't read this slide. It's going to be on how you're paying doctors. And it's going to be now more on how you're manufacturing your product and specific to complaints. And privacy also is, I see that those needs ramping up. Be prepared to defend your open payments. Everything's reported, right? Presuming the company has reported. And I should say, if you're the target of the purchase, be prepared to defend them. If you're purchasing an organization, it's a great place to go and read about how they're spending their money on consultants. The data room, I'd say the headline for this is do not put ACP materials in your data room. Seems kind of obvious, but don't do that. I would throw all this stuff in there. Like anytime you paid a doctor, that should be in there. And so if your board is saying, hey, and I know I'm flipping back and forth a bit here between seller and buyer, but if you're the seller, if you're the compliance officer at a seller and your company, the board is saying we're going to sell this company within a year, make sure that all these agreements are executed and up to date. If you're paying Dr. So-and-so and he's your favorite KOL, he better have an up-to-date consulting agreement that you're going to put in the data room. A lot of times we come in and do audits and it's like half the contracts are expired or, oh, the CEO signed that guy up, so we never memorialized that arrangement. Like that's not going to fly with the buyer, So, and then all your grant agreements, you should have a process for providing grants. You should have a grant committee that meets and makes decisions based upon the nature of the research and the value, not, someone being a big customer, obviously. I'm seeing gets kind of hairy with FDA quality related materials. You know, your quality function is going to decide. But there's so much in the QMS, right? That I don't know if that's going to be feasible to put that in the data room. But obviously, the strategic's going to want to dig into that, so they're going to need to gain access to that. Reps and warranties. You'll be, when you're getting close to the deal being done, you're going to have your buyer-seller agreement, and you're going to have sections in there on reps and warranties that relate to all these laws that we cover, or all of these laws and more. Right? So you're going to want to make sure if you're a buyer that you're not using an old form that doesn't talk about GDPR. And if you are a seller and you're not operating in Europe, you don't want GDPR in the agreement. If it's in there, strike it. Say, we don't operate in Europe, so we're not going to make a representation about GDPR. We don't have any data coming from. So the idea here is with these reps and warranties is making sure that it applies to you. So again, if you're the buyer, that you have up-to-date warranties and reps. And like Paul tells me, not infrequently, okay, we've got a new privacy law in such and such state. You're going to want to add that in here. Hey, you guys are following this law, right? Because like Jesse said earlier, some of this liability carries through, maybe it doesn't. This agreement will be important at that time. And maybe if you're not sure they're going to follow the laws, then you have some sort of carve out, and maybe you take money and hold it in escrow, and that money comes out later if there's no claims, for example. Sellers, I mean, it goes without saying, but make sure you're being truthful about your representations and warranties. There's times where it's not uncommon for a seller to say, well, we did have that warning letter. Do we need to talk about that? Yeah. You don't want to be hiding things, right? But, if it's a 483, I don't know, you're going to need to massage that language. 43s are pretty common, right? If you've got especially as your company gets bigger, the higher the likelihood that FDA is going to discover something wrong on a routine investigation. This virtual investigation thing, I'm not a fan of that. I don't think I appreciated how much that's apparently happening. I think for my tax dollars, I'd like to see the government on site, but that's a different CLE, I think. This is my wrapping up slide here pretty quick. So I'm actually reading to my daughter here. She's going to prom on Saturday, so she's growing up now. But I'm reading the Big Bad Wolf to her there. So that Big Bad Wolf is the regulator, I think. So these are some case studies just from my years of doing this. I'll kind of hop around on this list. One that I often talk about, I'm going to start down here. Once had a client where one person in a company decided it was a good idea to pay for a mailer. So they wanted to share information about their product. So they worked with a physician, and then the physician took their database of patient information out, and then the company, through this product manager or whatever they were, paid for the postage, right? You can't do that. You're not supposed to do that. So if you have any marketers asking you to do co-markets with customers and it involves PHI, you can't pay for any access to that PHI, not even mailing, blah, blah, blah. Be really careful with that. Those rules are buried in a final rule, a preamble to, I think, Paul's like a 2012 omnibus rule for some changes to HIPAA. But this turned out to be the reason a strategic did not buy a company that I worked with. So that little thing, which in my own mind, I was like, I don't think that's your reason. I think it's something else. But you can be subject to really strict review. So, be careful. Obviously be careful, but just be mindful that these privacy issues do show their faces, and you might have some really weird thing come up that you're not even aware of. Too much access to PHI. seen situations uncovered in diligence where it turns out the target company, actually one was going public, for example, and they some of their folks were actually getting too much into the patient information, which arguably took them beyond a mere supporter from a reimbursement function and got them into a situation where they were more like a business associate or even a covered entity. I've seen situations where the compliance program is kind of nascent, non-existent, pull that 3-ring binder off the shelf and blow the dust off. I've also seen really effective compliance programs, and companies get gold stars from strategics looking at them. I already talked about how I've been on conference calls for 30 minutes, and they're like, okay, that's our diligence for this acquisition. It's like, wow, are you investors in Elizabeth Holmes Company, maybe? That you really do want to dig in, get under the fingernails. What else is interesting on here? There was a company that we worked with that attorneys in DC dreamt up some quality issue that didn't exist, and that was the reason why they said they didn't buy the company, only to have another strategic come in, look at quality very closely. Yeah, it was like a month, and they ended up buying the company. So you see it all kinds. Often see off-label promotion and use. I think, in my mind, having done this for a long time now, people are very afraid of off-label promotion. I think it's a big deal. I'm not here to say you shouldn't worry about it, but and they're actually, let me explain that a bit, unpack that further. They're afraid of off-label use, really. You should be afraid of off-label promotion. Your company should not do it. But physicians will use products off-label. So I remember when I worked at EV3, we had a biliary stent franchise that was used, those products were used off-label nearly all the time. The company went on to get them approved for on-label uses after the FDA met with a bunch of companies that were in that biliary stent business. But I would, if you are looking at a target and you're strategic, just because the product is used off-label doesn't mean you should walk away from that deal necessarily. Maybe you look at it from a different angle. What will it take for us to get that use on label? Maybe that company doesn't have the resources to do that because it's PMA and you do. So there could actually be a diamond in the rough there, for example. And how do you find out if a company is promoting their product off-label? Look at their websites, hire an expert. You have your own internal experts. Look at their promotional materials. Maybe you could even do a ride-along to see how they pitch the product. I think that's probably a controversial concept, but if I were a buyer, I would, why not? Hey, can we go ride along with one of your reps, see how they sell the product, see how they interact with physicians? Going back to Theranos, I don't know how that happened because that to me is a diligence failure, and I have 5 minutes, thank you. Getting the hook. But that is one of those deals where I read that book, and we've done CLEs on that topic. I did one at Mitchell Hamlin, which was a lot of fun, and it watched the Netflix and all that, and it's just like, wow. I mean, that is like the antithesis of adequate diligence. How that was not discovered immediately is just mind-bending to me, especially having worked at a lab, because I actually remember having lunch with a friend, Amy Follower, down in Nicollet Mall, and we met with a couple folks that were kind of a me too to Theranos. And me having a laboratory background, I was kind of excited to meet with them. And I'm like, how are you going to get this machine that's the size of a Volkswagen into this like little box? And it's like, oh, well, we're going to figure it out. And it's like, you're not actually. You can't do that. So just kind of in closing here, how should you prepare if you're the buyer? List out your questions ahead of time and don't wing it. I gave you 20 questions that you can start with. Take time to perform your diligence activities. Get experts involved. I mean, that's one thing I see a lot if I'm representing the seller. And by the way, bring your outside counsel in on those calls if you like. It's all lawyers on the calls anyways. They're not going to be afraid because they might be able to help support you. But sometimes the experts that are, or the people asking diligence questions are asking really kind of 101 questions, where I'm kind of wondering, are they going to ask about this? And they don't. And they're asking about just more basic things. So you're going to get your experts involved. Review the materials. Don't forget about promotional materials. Nate's going to really focus on that. That's critical. And I don't want to steal Nate's thunder, but he's seen things where he's like, company X buys company Y, and then company X afterwards is like, oh, we can't promote it for that? What? It's like, how did you not discover that in diligence? That's crazy. You just spent huge money for this company. Interview people live. Don't just live in the data room. I think you can learn way more about people live, and a lot of times people want to share information with you. Don't get deal fever. Be willing to walk away if the juice isn't worth the squeeze. That's where I know a colleague had said, and she works in-house, but she was on a couple deals, and after her diligence, she had to go to, essentially up to the CEO, big company, and say, no, this is bad. You don't want to buy this company. So I'm sure the BD guys on that are like, are you kidding me? I've been watching this company for, years. They're great. And then that's where, again, to Jesse's point, we're not M&A lawyers, but maybe you can get creative and say, we see this red flag. We're going to park X dollars in escrow. If there's no claims in 5 years, you get the money. If there are, then we're going to use that money. We get it, or we use it to defend the claim. Follow your intuition. If something feels off, dig deeper. Consider asking if you can do ride-alongs. I already talked about that. Seller, this is obvious, but if you're going to sell your company in a year, go through Mark's 20 questions and make sure you're all polished up on those. That's the time to start remediation activities. Nobody expects you to be perfect. If you've got your QMS is messed up, for example, start fixing it. It's about the remediation. Know your risk areas. If you're in orthopedics, for example, sorry to pick on orthopedics, that's a space that the government, in their mind, they think it's susceptible to bribery. So you're going to want to know that, because the person that's buying you is going to be knowing that. So they're going to be particularly keen on your compliance program if you're in certain segments. All your contracts should be current, executed, meet the safe harbor. I'm talking about the personal services and management contract, safe harbor to the anti-kickback statute. If you don't know the answer, don't guess, obviously, right? Review your reps and warranties carefully. Don't disclose ACP materials. Know your system. To err is human. It's human. It's about remediation. Show that your systems work. I know when Amanda and I audit, and others in our firm, we're kind of like, oh, good. There's something that was broken and they fixed it. That's like a positive to a compliance auditor. And be ready to be interrogated over quality matters. That's my time. Any questions? Yes. Thank you. Rebecca, got a question from the audience. Do we have any questions online? Okay. People online, please feel free to ask questions.
So Mark, you referenced reimbursement market access as another category. Many companies, and I'll use InspireMed as one example, are very involved with the direct to patient. And so in the context of your comments, any hot topics, any voice of reason to layer on top of that effort from companies as they counsel patients directly or help educate patients directly?
That's a great question. Yeah, I think, there's been this, you've probably been at some companies where, you've got a reimbursement support function. I've seen them they're outsourced, say, to Priya or Argena or whomever, JDL Access, and then they're brought back in-house. And I've seen them kind of go like in and out sometimes. I feel like lately I've seen more going in-house. So people like the control. Challenge with in-house is that you then build it, you're kind of stuck with it. If it doesn't work, it's easier to fire a consultant than a bunch, a team that you just established in house. But what I would do in those situations, I would audit them annually, at least I would think, maybe biannually, or excuse me, once every 2 years or once a year, I would say. But policies and procedures are really critical. So we're actually working with a client right now on just establishing a program that they're bringing in house, and so we're very keen on the 3 areas we talked about today. Making sure the privacy piece is kind of obvious because you're working with a patient. So you're going to need a patient authorization, a robust process that the patient says, I'm letting you have access to my data. Or you could become a business associate, which is another option. And a lot of clients are taking that route, especially if they're related to AI. They have AI applications or other applications that require a lot of access to patient information. So I'd look at the privacy. You also want to make sure the cases you're supporting are on label. So a knockout needs to be, we're not going to support any off-label cases. So there's FDA ramifications, regulatory ramifications. Then from the compliance perspective, that's where it's deep, right? So a lot of these programs, they say, what can we do for a rebate if the payer ultimately denies coverage and we've already implanted or treated the patient? So we've actually recently done some work with copays as well. What are the options for waiving those? There was an advisory opinion that came out that was friendly to industry. We actually, Jesse just also submitted an OIG advisory opinion on a similar question, and we're drafting another one for a different client on a reimbursement-related question. So those support programs touch all of the compliance hot buttons, if you will, the regulatory privacy compliance. And I think just staying on top of them, I think it can be a really great model, especially if it's in-house and you're controlling the process. But you want to kind of keep on top of them because it can be an area where you can really go off the rails. If there's, especially if there's some sort of reimbursement guarantee associated, you want to be careful with those. Jesse, question?
I was just going to add to that. Really, so OIG has, especially in some recent advisory opinions, has been, like Mark kind of alluded to, has been a lot more permissive in allowing kind of broader support than I think most of us would have assumed they would allow even a few years ago. But it really comes down to, and OIG is relying on things like under the beneficiary inducement CMP, they're relying on patient access to care, right? And so, but having legitimate purposes for patient access to care is the key there. And you see people trying to couch things as patient access to care that they really aren't. So that's the other part of it, is evaluating those programs to ensure the legitimacy to meet one of the exceptions to, for example, the CMP.
Thank you. And I want to have Amanda come up. Maybe as you're walking up, any other questions? I think I'm at my time, but I wanted to just add one more comment on this topic of reimbursement. I know Amanda sat on the committee that reviewed the AVIMED guidance for reimbursement support, and among the committee there was not. I want this. Ultimately, the committee decided not to change anything. If you remember when the AVIMED code was updated, I think it was went into effect January 2020. Somewhere around there, yep. June, nothing was changed in that section, but there was disagreement there wasn't 100% alignment on the committee with reimbursement support. So for me, that is a hot area to keep track of if you're providing reimbursement support, because at any moment you could have a whistleblower, that could become an interesting de jure kind of prosecutorial subject of interest. You just want to be careful with that. So I'm at time. Thanks, everybody.
Thanks, Mark.